Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here today. You have been summoned here for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what options you have regarding your case. Now, the case that you have is classified as a misdemeanor case. Criminal cases falls into one of two categories. It's either a felony case or a misdemeanor case. And the difference between the two are as follows. Your felony cases are what we call your most serious type of cases. For example, it could be a murder, it could be an aggravated sexual assault, it could be an aggravated robbery, it could be a burglary of a habitation or building, it could be a serious type drug case. But for the most part, with a felony case, they have, it's either a state jail felony all the way on up to a capital murder. For capital murder, your punishment could be life or death. Well, you can get up to at least, like I said, in a felony, well, in a capital murder, it's life or death punishment, fine up to $10,000. If it's a first degree felony, 5 to 99 years to life, or fine up to $10,000. For a second degree felony, it could be 2 to 20 years, fine up to $10. Third degree felony, 2 to 10 years, fine up to $10,000. And for a state jail felony, it could be anywhere from 6 months to 2 years in the state jail. Now, with the felony cases, the second degree on up to capital, to a capital punishment, you could be sentenced to what we call TDC, the Texas Department of Corrections. Now, on a misdemeanor case, you cannot be sentenced to the Texas Department of Corrections. Your misdemeanor cases could be assault, family violence, or just a regular assault case. It could be a possession of a controlled substance like a penalty group 1, where you have, or it could be synthetic marijuana, it could be possession of marijuana. It could be a evading arrest case or evading detention. It could be a trespass case, criminal mischief case. It could be a theft type offense. And it could be unlawfully carrying a weapon, a failure to identify. But for the most part, your misdemeanor cases falls into 3 categories. You have the Class A misdemeanor, which is the highest misdemeanor, the Class B misdemeanor, the next highest, and then Class C misdemeanor, which is the lowest. Class C misdemeanors are your cases, for example, they're mostly traffic offenses. Normally, a person get a speeding ticket, or they may get some type of traffic offense. They won't come to this court initially for that case. They'll be sentenced to, well, they have to go to the city court, which is the municipal court, or to the JP court, which is the Justice of the Peace. Now, if those cases are appealed up, then they come up to this court. And we handle apart from the Class C appeals, we also handle Class B and Class A misdemeanors. The range of punishment for the Class A misdemeanor is anywhere from 0 days to 1 year, which is 365 days in the county jail, a fine from $0 or anywhere in between up to $4,000, or you could be given both such fine and confinement. For Class B misdemeanor, the step lower than the Class A, the range of punishment is anywhere from 0 days to 6 months in the county jail, or anywhere in between, a fine from $0 to $2,000, or anywhere in between. Or you could be given or you could be given both fine and confinement. Now, as I said earlier, you cannot be sent to TDC, the Texas Department of Correction. However, you can be sentenced to the county jail. Now, as a defendant in a criminal case, that's and I'll go over the paperwork that was just passed out on the clipboard. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. So those are your three options regarding your right to have an attorney. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have enough money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. The prosecutor is the assistant district attorney. You cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And that waiver is the second page on the clipboard that you have. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of the document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you state that you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed counsel, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, finally, if you want to waive your right to an attorney and represent yourself, then you will put your initials on the fifth line to the left, and once you finish initialing one of the 5 lines, at the bottom where it says defendant, you will place your signature, and where it says date, you will place today's date, May 11th of 2021. Now, at the top of that document, it says state of Texas versus, in that spot, you're gonna put your name on that line. And then if you don't know the number, we'll have someone to fill in the number for you. Now, for those of you who are waiving your right to an attorney and you wanna represent yourself, you will have to read and sign the second page, which is the waiver. And I'll go over that waiver right now. And it's titled, Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 11th day of May of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign where it says defendant. You'll put your signature there and you'll place today's date, May 11th of 2021. Now, you also have a right to have a trial by jury. And what a trial by jury is, where that young man is sitting over there. We call that area the jury box. 6 citizens from Jefferson County will be selected to listen, to examine, and basically to be as jurors in your case. After listening to all of the evidence, after they've deliberated, they will decide whether or not to find you guilty or not guilty. Now, sometimes it may involve, it could be a mistrial, or it may end up in a hung jury, which means they could not agree. But in essence, you still have a right to have a trial by jury. Now, you also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case will only come before the judge. So if you have a trial, we call that a bench trial. If you enter a plea of guilty and no contest, and you have a plea bargain agreement or an unagreed plea bargain, it'll come before the judge, and the judge will decide in the trial whether or not you're guilty or innocent. And in a plea, the judge will decide whether or not he will follow or not follow the plea bargain agreement. You also have a right to have witnesses to come to court. And what witnesses do, they can testify. They can testify either for you or against you. Where that young lady is standing, that is called the witness stand. You can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses, which means you have a right to, you can give up your right to have witnesses, to call witnesses to come into court and testify. By doing so, you will not have any witnesses that you're calling. However, the state will call witnesses to testify in the case. You also have a right to have discovery. Now, discovery means you have a right to see the evidence that the state has against you. For example, you have a right to see the police reports. You have a right to see witness statements, see the videotapes, or whatever evidence that they have. You have a right to see it or have access to it. Now, if you have an attorney, your attorney will be given access to it. If you're representing yourself, then you will be given access to it. Now, you also have a right to give up your right to have discovery, which means you have a right not to see the evidence. If you choose not to see the evidence, you'll be waiving or giving up your right to have discovery. If you are not a U.S. citizen, on a plea of guilty or no contest, it can result in deportation. What deportation is, you could be kicked out of the country. Or on a plea of guilty and no contest, it also may result in exclusion from admission, which means that you could be denied entrance into the country. Or you could be denied naturalization, which means if you make an application to become a citizen, they can deny that your application for citizenship. If you are represented, by an attorney, or if you're not represented by an attorney, either way, if you are represented by an attorney, as I said earlier, your attorney will have an opportunity to talk to the prosecutor to see if they can work out a settlement on your case. Or if you're representing yourself and you sign the waiver, you'll have an opportunity to talk to the prosecutor to see if you can work out a settlement in your case. The settlement we call a plea bargain agreement. If you are able to work out a plea bargain agreement, it will come before the judge, the court. Now, the court does not have to follow the plea bargain agreement. If the court does not follow the plea bargain agreement that you have entered into with the state, then you will have a right to withdraw, which means you have a right to take your plea of either guilty back. You can take it back. Now, if the court does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you would like to have a higher court to look at your case because you think that you've been wrongfully convicted or the court committed an error by convicting you, and you would like to appeal. Now, if the court follows the plea bargain agreement, and if you would like to appeal, you would have to get permission from the court. If the court gives you permission and you file your appeal, then it will go up to the Ninth Court of Appeals. They will get the case. The Ninth Court of Appeals actually is located right above us on the 3rd floor. They can either deny your appeal or grant your appeal. If they grant your appeal, they can find you simply not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, the Ninth Court of Appeals, that is, if they deny your appeal, you can appeal it to a higher court than them. That higher court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be doing it on your own without the assistance of a lawyer. You'll be representing yourself. And if you file a pro se petition, as I said, they can grant it or deny it. If they grant it, then they can simply find you not guilty, case over, or they can send the case back down to this court, order this court to give you a whole new trial. Or if they deny your pro se petition, then at that point, your conviction will stand. Now, you'll have the opportunity, either if you represent yourself or you're representing or if an attorney is representing, you'll have an opportunity to enter one of 3 pleas. You can enter a plea of not guilty. You can enter a plea, not guilty means you're telling the court you didn't do it. Or you can enter a plea of guilty, and basically, when you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea, the 3rd plea is no contest. And if you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges against you. So you can enter, so let me repeat, you can enter a plea not guilty, guilty, or no contest. Now, everyone here, that's for arraignment. You've been arrested. You spent some time in jail. It could be 1 minute or more. I don't know how long you stayed in jail. It could be a couple of days, months, I don't know. But anyway, the time that you spent in jail can be used as credit toward your punishment. For example, let's say the state and you have reached an agreement, a plea bargain agreement, 5 days in jail. Let's say you already spent 5 days in jail or more. Then what will happen is they can give you credit for the 5 days, and you will not have to serve any more time in jail because you'll be given what is called credit for time served. Now, if you had less than the 5 days, then you would have to do the remainder of the time. If you did 4 days, you may have to do 1 or whatever. Now, if the state offers you a fine and court costs, every day that you spent in jail, if it's 1 day, 2 days, 3 days, for whatever, Every day you spent in jail, you get credit toward fine and court costs at $100 per day. So let's say they offer you fine and court costs of 5 days of $500, and let's say you spent 5 days in jail. 5 days in jail is $500. That goes toward your fine and court costs. That means that your fine and court costs of $500. That means you won't have to pay anything because you've already spent enough time in jail, and so you'll be given your fine and court costs will be taxed and retired. In essence, you've already paid it by the time that you spent in jail. Now, earlier I mentioned that uh, your punishment can either be a fine, a court costs, or fine and court costs. Or, well, excuse me, it's a fine and jail time, or fine or jail time. Okay, so we talked about you can get a fine up from $0 to $2,000 for Class B, or jail time from 0 days, 180 days, or you can get both such fine and confinement. Okay, I've said that to say this. You can also be given, you may be given probation. Okay, what the probation is, there are two types of probation. One type is called unadjudicated probation, and the other type is called adjudicated probation. The difference between the two, with adjudicated probation, it does, we call that regular probation, it does result in a conviction on your record. However, if there's something that is called judicial clemency, where the court can set aside the conviction, in essence, you no longer have a conviction. The way it operates, you have to, one, successfully complete the probation. Two, the time on probation has to expire. You can't have any more time on probation. And three, you have to be successfully discharged, meaning to be let off of probation. If those three things happen, the court can allow you to come back in the court to withdraw your plea of guilty or no contest. And if that happens, then any complaint, information that has been filed against you, any complaint information that has been filed against you, then the court can set that aside. Hold on a minute. I would say any complaint information or affidavit that has been filed against you, then the court can set that aside. And once the court set that aside, your conviction will be set aside, or they'll be dismissed, and then your conviction will be set aside. In essence, you will no longer have a conviction. And, however, if you get another conviction later on, then the case can be resurrected, revived, and brought back up and used against you. And if you try to get a license with CPS, then they could deny giving you a license, or if you already have a license, they can revoke or suspend your license. That's with the regular probation. Now, with the unadjudicated probation, we usually call it deferred probation. With the unadjudicated probation or the deferred probation, it does not result in a conviction on your record. And if you successfully complete that unadjudicated probation, the case will be dismissed and you may qualify for non-disclosure. A non-disclosure means we cannot disclose or tell the general public that you were on deferred adjudicated probation for this offense. However, if you violate your probation, then the state can file a motion to revoke your unadjudicated probation. You could be arrested. You'll be entitled to have a hearing. And if the court determines after the hearing that you have violated your probation, the court can revoke your probation. And if your probation is revoked, obviously, it may result in a conviction. And if you have a conviction, you can't get the case dismissed, and you cannot get a non-disclosure. Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. So if you're a first-time offender, that program actually results in the case being dismissed and it could be expunged from your record. Expunged means wiped off, erased, or deleted from your criminal record. Now, the way it works is you have to file an application to get into the program. Normally, well, you have to have a lawyer to assist you with filing that application. And two, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. Three, it has to be your first offense. You cannot have a criminal history. So if you meet any one of those criteria, then you could apply for pretrial diversion. And as I said earlier, you could get it, if you complete it, you could get it expunged, which means erased, deleted, or wiped off from your record. Now, the other program that they have, the district attorney's office, is called Veterans Court. Veterans Court is for veterans. If you are a veteran of any one of the branches of the United States military, if you are a veteran of any one of those branches, you may qualify for Veterans Court. And if you get into Veterans Court, it's part of the pretrial diversion program. Cases, you complete the program, case dismissed, you can get it expunged from your record. Okay. Now, this court, County Court at Law number 2, Jefferson County, Texas, has a program that I started that is called the Community Safety Initiative. For short, we call it the CSI program. With that program, we have partnerships in the community. Now, the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And the way the program works is the partnerships that we have in the community, it involves various different issues or subject matters. For example, if we have a partnership with Spindletop MHR. All right, that program, Spindletop has a mental health program. They also have a drug treatment and alcohol program. So anybody who has mental health issues, then they can have a private interview, an assessment can be done, a treatment plan can be worked out by Spindletop. It could be either outpatient or inpatient. If somebody has a substance or drug abuse problem or alcohol abuse problem, or maybe they're in denial, they don't think they have a problem, but they have a program at Spindletop for youth that is called ATAR. It stands for Addiction Treatment and Recovery Program. And we have relationship with Ozar. We can refer people to Ozar. That's the local drug and alcohol council in this area. They can do Spindletop with ATAR as well as Spindletop, not Spindletop, ATAR as well as Ozar can do a screening, interview. They could develop a treatment plan, either outpatient or inpatient, for individuals who would like to get some assistance in those areas. If you are unemployed or you have a job, you want to get a better career, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. If you're interested, you can be trained in either the hotel industry, the shipping industry, or the chemical industry. And once you get trained in any one of those areas, they will assist you with getting employment in the field that you're trained in. If you have not completed your high school diploma, Spindletop, as well as the CICE program, has a GED program where you can get your GED. Now, All of those programs that I just spoke of are free. Doesn't cost you anything. Only thing you have to do is say, I want to be in the program. I want to participate. The other thing about the program is that all of those programs could be used as community service. So if you have been ordered to pay a fine and court costs, and if you can't pay your fine and court costs at that time, then we can put you on a payment plan to pay it off in monthly installments. Or if you can't pay it off at all because you are indigent, you don't have the money to pay it off, then we can convert your fine and court costs to community service. And I tell people this all the time, you could kill 3 birds with 1 stone. And what I mean by that is this. You ought to pay a fine and court costs, but you can't pay the fine and court costs. That's 1 stone. We convert it to community service. And if you're in one of the programs, let's say you're in the job training program. While you're in class for 1 hour, being trained for a job, that 1 hour is 1 hour of community service, and it's $12.50 that goes toward your fine and court costs. So in an 8-hour day class, you are contributing 100 hours toward, $100 toward your fine and court costs, and 8 hours toward your community service. Okay, so you're paying your fine and court costs, you're doing your community service, and then in the programs, you're doing 3 things. You're doing 1 thing, but you're getting credit for 3. Okay, so say if you in drug treatment, it's the same thing. Alcohol treatment, same thing. Mental health treatment, same thing. Or if you're in a GED program, same thing. So while you're working on your GED, you're paying your fine and court costs, and you get credit for community service. So that's our program that we have, the Community Safety Initiative. So that program started in I think March of 2017. So we've been doing it for 4 years now. And so with that program, if you're interested, as I said it earlier, you can just let us know that you're interested in one or more of the programs. I tell people this all the time: when you come to county court at law number 2, we don't have court as usual, we have unusual court. And the reason why I say that is not because we're different, but because we're trying to make a difference of the lives of the individuals that come before the court, and we're trying to make a difference in Jefferson County by making Jefferson County a safer place. We're also, with this program, we're producing productive people. And by producing productive people for the most part do not commit crimes. And finally, with the program, we do not just arrest the problem, we address the problem. And we believe that by addressing the problem, we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. Now, we have some individuals, some people here from Spindletop, and we're going to have Deputy Hinton to come forward. He can tell you about the program that Spindletop can offer. And at this time, I'd like to introduce to you Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner here, Mr. Jess. I also have another lady in the back who is Mrs. Misty. They are qualified mental health professionals. The reason we're here is because the judge has invited us in his courtroom because he cares about each and every one of you. And what we found is people who frequent the legal system in and out of the jail sometimes have underlying issues. And so we want to address those issues. Sometimes those issues are mental health illness or substance use disorders. If we can help you with those items, then we can get you out of the legal system. That's our goal and that's our objective, is to get you out of the legal system and get you into a quality of life that best suits you or what you would like to have towards getting out of your legal predicaments. So what we're going to do today is, as the court proceeding goes on, I'm going to go and speak to every one of you and talk to you. We found there's really 2 obstacles in this situation. The first one is we don't know if you have a mental health issue or substance use disorder unless we ask you. So that's what we're doing this morning. We're going to ask you. And also, we don't know if you don't tell us. So that's gonna be required of y'all, if y'all choose to share that with us and give us an opportunity to provide resources, options, services, and direction on how y'all can better treat yourself, if that applies to you. If it doesn't apply to you, maybe it applies to a family member, you can get the resource materials and bring that to them and help them as well. But as the court proceeding goes on, we'll be talking to y'all, and y'all are welcome to visit with us. We have a private room in the back where we can speak to you. Everything is HIPAA regulated. The information is private. No one's going to know about it. It's all protected by law. So everything, again, is going to be confidential. And like the judge said, it's all free. So I would encourage you to take advantage of it. Great opportunity if any of this applies to y'all. Do y'all have any questions?
Okay.
Thank y'all very much.
Okay, thanks a lot, Deputy Hinton. And now, ladies and gentlemen, now just to follow up on what Deputy Hinton said in reference to our program, we also do have what is called Aftercare. And what Aftercare is, if your case is disposed of, we have a relationship with the Spindletop, where they will have mental health deputies to assist you while you're out there in the community. Sometimes individuals need assistance with medication, with housing, with benefits, or whatever. Spindletop have all of those services that they can provide. And by doing so, by them being engaged with you in the community, that prevents you from coming back into the system. So our program not only is a program that also deals with why you had your case is pending, but even after your case is over, services still can be provided to you, okay? And one thing I can say is that with those services that Spindletop provide and that the services that all of the agencies provide, it is a good networking tool, and it also provides you with resources that can help you not only now, but also later on in your life, okay? So at this time, we're gonna have our staff collect the information from you that you was able to fill out on the clipboard. Now, I think this one gentleman came in late. We need to give him a clipboard. Now, sir, that information that's on the clipboard, you can take some time and read it. I went over it, but if you have any questions, we'll provide some assistance.